Today's oversight hearing focuses on a critical facet of U.S. immigration policy. The Executive Office for Immigration Review, or EOIR, is the linchpin of immigration law as it administers, among other components, the U.S. Immigration Courts and the Board of Immigration Appeals. The adjudication and appeals of immigration matters is of critical importance to the proper administration of justice in this country, and we must ensure that our immigration laws are interpreted as Congress intended. As a former immigration practitioner who regularly appeared in immigration court, I certainly understand and appreciate just how important it is that the courts are administered effectively and in a way that maximizes docket management and minimizes fraud and delay. Unfortunately, EOIR has been plagued by management problems that have consistently hampered its ability to operate the courts. During the past administration, the Department of Justice's Inspector General's office found that the office engaged in nepotism and other inappropriate practices. These disturbing findings served as a distraction for EOIR, making it impossible to focus on much-needed improvements. Additionally, a 2014 server crash paralyzed the courts nationwide for several weeks, again necessitating the allocation of resources away from management and oversight of the agencies. The policies and practices instituted during the Obama administration served a decidedly political agenda throughout the federal government, and EOIR was not spared. Companion memos to those issued by the Department of Homeland Security on prosecutorial discretion and administrative closure policies raised, at a minimum, the specter of collusion between the Department of Justice and the Department of Homeland Security. The prioritization of recent entrants, including the surges of unaccompanied minors and family units, likewise were ill-advised and poorly executed. Ignoring the irrefutable evidence of spikes in asylum fraud before the court, EOIR chose its focus based on political expediency rather than judicial prudence. It is against this backdrop that the incoming leadership must begin to restore this agency and, where necessary, needs to overhaul it. Of utmost concern to this subcommittee is the current backlog of pending cases. I am appalled, but really not surprised, that the previous administration created conditions that ultimately resulted in a backlog of almost 630,000 pending cases nationwide. This number represents a 22% increase in fiscal year 2017 and is simply unacceptable. The Government Accountability Office's recent report on management practices at EOIR and the backlog identified several possible solutions, including reforming the hiring process for immigration judges and updating internal oversight practices to ensure better docket management. The GAO report noted that continuances were a contributing factor to the backlog. The report found that from 2006 through 2015, the court saw a 23% increase in the grants of continuances. I would never suggest that continuances be disallowed. They can be valuable for attorney preparation. I've experienced that myself for purposes and are essential when critical evidence must still be collected. However, the rash of continuances used for the purposes of delay constitute an abusive process that must be stopped. The July 2017 memo from Chief Judge Mary Beth Keller outlining EOIR's continuance is a tremendous step in curbing this abuse, but represents only one of the solutions to reduce the number of pending cases. The GAO report further noted the inefficiencies associated with the hiring of additional immigration judges. As your written testimony acknowledged, the Trump administration, through its immigration principles, has called for the hiring of an additional 370 immigration judges. I remain concerned that EOIR must reevaluate hiring practices and processes to meet even a fraction of this goal. The time between an initial job posting to the actual onboarding of a judge must be reduced. Finally, I have long spoken about the need to modernize our immigration system. One of the key components must be the modernization of our immigration courts. EOIR currently lags behind other federal courts in terms of basic items, such as filings and other similar items. This was never a priority for the previous administration, as the U.S. immigration courts are one of the last remaining federal adjudicative bodies relying on paper filings. Employing an e-filing system would drastically reduce the need for more filing space and overall reduce the number of lost filings that could also lead to unnecessary delays. In addition, EOIR relies on other technology such as video teleconference system or VTC, but there are concerns that this equipment is either outdated in some locations or not operational at all in others. With the challenges facing EOIR today and the solutions of the new administration, I am hopeful that we can work together to bring real change to the agency and continue the goals of modernizing and reforming our immigration system. Before I recognize the gentlewoman from California, I would ask unanimous consent to place into the record a statement from Judge Ashley Labrador, President of the National Association of Immigration Judges.